ಕಿರಣ್ ಕೂತ್ಕೋ ಕೂತ್ಕೋ ಬಂದಾಗ ಎದ್ದೇಳು ಅಲ್ಲಿಂದ ಕೂತ್ಕೋ.
I appear for the petitioner in this case.
What is this? You've got me on a Sunday also.
My Lord, I am deeply obliged, my Lord. I apologize for your Lordship being here on a Sunday, my Lord. My Lord, but the urgency in this is there was an impugned order passed on 5th of April, my Lord, for demolition of certain buildings. But we received that order only on the 9th.
Sorry, my Lord. Received the order on the 9th, my Lord. The petitioner received the order on the 9th. And of course, 10th was a holiday, so they sent it to us. But we thought they will give us some time being holidays, but they came immediately with the squad.
When did they come?
They came on yesterday, last morning. But they told us the previous evening, we are doing the markings. They did the markings.
No, they've gone there to do the markings. My preliminary instructions are that they've gone near the property. They've enmarked. There was a joint survey. Since there was a direction by this honorable court, a joint survey was conducted and 40.
Which is that? Which is the order?
No, Your Lordship, my instructions are that there was a PL which was filed. In that PL, there was an order to initiate action. So 64A notice, 64A proceedings have been concluded. So now there's an order for eviction. So we have gone there we have enmarked the place to evict them.
Evict them or demolish the property?
No, I don't know.
What is there in the property?
Lord, it's a school building and an orphanage and staff quarters, my Lord. So she runs a not-for-profit where the children are educated in that area. So there are 5 buildings, my Lord, in total. So there's a school, there's an orphanage, staff quarters, her residence, and there's a prayer hall, my Lord. So these are the 5 buildings which have been earmarked for, and 3 of them have been earmarked for demolition, my Lord. And one of them is the school building that has been earmarked for demolition.
So they've not produced any documents about the building. Neither have any instructions regarding the building there.
No, but 10th is 11th was a holiday, and the 12th was second Saturday. Why is this demolition squad active on the holidays?
No, it's not that we are active. We have gone there to enmark it.
Like on there to enmark it, if nothing happens, then you will finish it off. And when did you serve the notice?
They have pasted a notice today, my Lord, in the afternoon. I mean, when I came to this court, I got it through a WhatsApp that tomorrow they are coming with the entire squad and demolish.
Put it, give me that.
Sorry, I
Ikade.
I did not first time to enlarge it.
ಎಲ್ಲಕ್ಕೂ ತಪ್ಪಿದ್ದಲ್ಲಿ ವೆಚ್ಚವನ್ನು ಮಾಡ ಪ್ರದೇಶದಲ್ಲಿ ಬೆಳೆ ಇದ್ದಲ್ಲಿ. Yes.
Lordship, leave it to your Lordship.
No, at least you should today. This is dated 11/4/2025.
No, I don't know whether when they sent it.
Which is how did you get this?
It was pasted on the wall today, my Lord, in the afternoon.
Today.
I don't know whether it was posted.
So why
today.
does the?
No, I don't think today.
Why is the department working?
No, not today.
On a Sunday to paste this.
No. On a Sunday they've not gone there.
So there is no problem with getting us sitting, whatever it is. It's citizens' right. We are always there. But on a Sunday or a second Saturday, why are you active?
No. My instructions are very clear that they've not gone near the property today, but they've enmarked it to a day before, your Lordship.
ಎಲ್ಲ ಬೆಳೆಸ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Which is that order in PIL?
No,
Which is that order?
My Lord, the order is not yet uploaded, my Lord. My Lord, what had happened was the PIL was disposed of in terms of this order, my Lord. And
which order?
In the impugned order at Annexure A. The impugned order was passed on 5th of April, and the PIL was disposed of on 7th of April, my Lord. And what was said in the PIL, I personally was appearing before the Honorable Chief Justice, my Lord. What was said is this particular PIL is disposed of in terms of the order. Respondent number 11, that is us, we are free to challenge that particular order.
Oh, that is all that was
Yes,
said.
my lord. It didn't go into the merits, my lord. There was nothing into the merits. Because it was already with
But
this.
there was a joint survey conducted.
That's all right.
That was not in
No, if Honorable the Chief Justice has given them liberty to challenge this order,
Please.
No,
you
but
should not render the challenge fait accompli
No, no,
by doing everything even before the challenge could be raised.
no, your lordship, my hands are tied without further information.
ಅಲ್ಲ ಈಗ ಫೈಲ್ ಇದೆಯಲ್ಲ.
A file ಇದೆ, but ಇದರಲ್ಲಿ
So we'll not permit demolition to happen or something. We'll take it up later.
ಆಯ್ತು.
But don't trouble them on
ಆಯ್ತು,
Saturday.
ಆಯ್ತು. ಅಲ್ಲ.
ಅಲ್ಲ ಈಗ ಎಷ್ಟು ಎರಡು if I see the petition, it is 2004 in the school is running. All eyes shut from 2004. Suddenly someone complained. Everything is woken up. And today in 2025, you want to demolish the property overnight because of an order. That too, the council says the Chief Justice has permitted the 11th respondent there, is it? 11th respondent to challenge the order. Travel. ಸುಮ್ಮನೆ ನೀವು ಬರ್ಬೇಕಾಯ್ತು. ಇವ್ ಸ್ಟಾಫ್ ಎಲ್ಲರಿಗೂ ಈಗ ಸಜಾ. ಎಸ್ ಅಷ್ಟೇನಾ? The petitioner claims to be the owner of a property in survey number 26 of Vadarahalli village, Belagomba Hobli, Tumkur Taluk, to an extent of 3 acres and
20 guntas.
3 acres and 20 guntas. The petitioner, being the owner, gets the land converted from agriculture to non-agricultural purposes on 12/5/2000, and in 2004 has constructed certain buildings and is said to be running a school, orphanage and other ancillary activities connected to the school. NGO, na?
Lord, it's mainly a school, my lord. Main thing is a
So
school.
and so. After about 20 years, a report is said to have been submitted by the fifth respondent, alleging that the fifth respondent, the range forest officer of Tumkur range, alleging that the petitioners have committed offences under the act in as much as they have encroached upon the land belonging to the forest, and directs handing over of possession within 30 days. The petitioner then challenges the said order in an appeal before the appellate authority, the fourth respondent. I'll state
No, ma'am.
fourth respondent. No action was taken in the teeth of the pendency of the appeal. It transpires that a public interest petition was filed before the division bench, in which the petitioner was arraigned as 11th respondent. During the pendency of the said public interest petition, an order comes to be passed by the appellate authority on 5/4/2025. Tribunal authority.
Authority, ma'am.
Appellate authority on 5/4/2025, holding that the petitioner is an encroacher of 3 acres and 20 guntas of forest land and allegedly directs demolition of the property within 5 days from the date of the order. The order is said to have been served upon the petitioners only on 9/4/2025, and on 12/4/2025, a Saturday, the notice is pasted on the doors of the school in which the property doors of the school in the alleged land, in the aforesaid land. It is then the petitioners come to know that the property would be demolished. The learned AGA would also admit that the forest officials have visited the property and have done the markings in the light of a joint survey conducted, and he has no instructions with regard to demolition of the property or otherwise. The learned counsel for the petitioner submits that in the public interest petition, when the impugned order was produced before the division bench has permitted the 11th respondent, therein the present petitioner, to challenge the impugned order, which is done in the case at hand. The matter is moved today for taking up of urgent hearing, though being a Sunday. The reason for moving is the apprehension generated by the forest officials in visiting the property and earmarking the same for demolition, as the notice would clearly indicate that that everything that is on the property will have to be taken off. In that light, to preserve status quo till the next date of hearing, I deem it appropriate to stall all further proceedings pursuant to the impugned order, I deem it appropriate to stay the order dated 5/4/2025 and all further proceedings taken or to be taken thereto till the next date of hearing. More so, in the light of the liberty reserved by the division bench as submitted by the learned counsel for the petitioner, that the petitioner can challenge the impugned order. List the matter on 22nd in the fresh matters list. The learned AGA to secure instructions and make his submissions on the next date. We'll have it uploaded now.
Much obliged.
Sincere thanks for the unnecessary trouble you
It's all right, because you said demolition, then
have. That is the reason.
demolition ಆದರೆ ಇನ್ನು demolish ಆಗಿ ಮಾಡೇ ಬಿಟ್ರೆ ಇವ್ರು ಏನು ಉಳಿಯುತ್ತೆ ಆಮೇಲೆ ಅಂತ ಅಷ್ಟೇ. That's precisely why I sat on a Sunday also.
And then she's a
Like,
ಕುಡಿ, sorry, yes. ಎಲ್ಲ ನೀವೇ ಅಲ್ಲ? Rahul?
1 to 7.
Learned AGA is directed, wife's notice for respondent 1 to 7. Copy ಇದೆಯಲ್ಲ?
ಇದೆ.
ಮಿಕ್ಕಿದೆಲ್ಲ ಹಂಗೆ ಇರಲಿ. ಕರೆಕ್ಷನ್ ಮಾಡ್ಬೋದು.
deeply obliged.
Yes.
It's okay. Now number 2. Double what? 90.